in respect of the respondent's conduct. The respondent being the president, by the way. The respondent is the president. The applicant is Asifwa. The respondent is the president. Then Godfred Dame says, my lord, the failure to give the chief justice, he takes out of the existing panel. Adibu Asedu, of course, is out. We know that because he's going to be on the panel for the committee that's going to listen to the Chief Justice in the substantive matter of the petitions against her. So he's out. And then Justice Bafuboni also takes out Justice Dako Asare, who was originally empaneled, takes him out. And then he takes out Justice Eje Frimpong, who was originally empaneled. So these are the three judges that get out of the situation. Three judges get out. And then three judges get in. Justice Leonie Kulendi, Justice Bafuboni, the acting Chief Justice, and Justice Amadou Tanko, all are three who come into the matter. The biggest controversy about this was the arguments that were made by the former Attorney General in court today. Now, he was concerned that Justice Bafuboni, being an acting Chief Justice, he said, is a direct beneficiary of this process. Therefore, Justice Bafuboni should not add himself to the panel, even though he does have the administrative right to empanel. Now, the Supreme Court heard the matter, and all 5 judges of this morning, including the 3 here, agree that the Chief Justice can sit. So they overruled Godfred Dame on that matter. I've heard Supreme Court judges give me several reasons why the court ruled this way. But then this evening, when I spoke to another Supreme Court judge, he's telling me one thing, that there's another argument that I need to bring to the attention of my viewers tonight, why Justice Bafuboni can sit. He says that to say Justice Bafuboni is a beneficiary of the process is not altogether wholesome and correct, because Justice Bafuboni has not been appointed the Chief Justice. He has not been told that he'll be appointed Chief Justice. There's been no announcement that he will be appointed Chief Justice. The reason why he's there is because he is in an acting capacity on the basis that he's the senior most justice at the Supreme Court. So he's not been appointed Chief Justice. He's acting in an administrative capacity as a senior most justice of the Supreme Court. And therefore, he's able to sit on the panel. Because tomorrow, if the Justice Tokono thing goes through and for whatever reason Justice Tokono doesn't come back, the president can decide to appoint Amadou Tanko as a new Chief Justice. And Justice Bafuboni will revert to his role as a senior most. The consistent and persistent Deputy Chief Justice is the senior most judge of the Supreme Court. So as a Deputy Chief Justice, he's only stepping in the role of the Chief Justice because there's an administrative issue that he has not been appointed the substantive Chief Justice. This is what the Supreme Court judge told me tonight, that must also form part of the information that I share with my viewers so that they can make their decision whether it was right or wrong. It was not technically wrong because he saw the court rule in that way, but the question is, was it morally right? Was it morally incorrect? It's up to you, viewers. Look at it and let's see what you think. But more interesting revelations. Now, it was these 3 judges who were added today that swayed the court away into a majority of 3. I'm not reading anything into that. 3 judges here who came in. Justice Leonie Kulendi, Justice Bafuboni, and Justice Amadou Tanko were the 3 who ruled in favor, who ruled against the application, and therefore the application fails. The 2, Professor Henrietta Mensah Bonsu and Mr. Justice Jehu, ruled in favor of the application, that the application should succeed. Justice Bafuboni sat on the panel as well. So this is the story from the Supreme Court today. At 7:30, they went to the court. They heard Justice Bafuboni was sitting. A lot of conversations about whether he should sit or not. An application was filed. The application failed. But I'm telling you what another Supreme Court judge told me about what happened. But the other story is that, coincidentally, it was the 3 judges who came in this morning who delivered the majority opinion, which we are yet to read sometime in May, I think another week or so. I'm guessing that the majority opinion will be written by Justice Leonie Kulendi, and the minority opinion will be written by Professor Henrietta Mensah Bonsu. But there was a showdown in court. The case is not over. There was a real showdown in court. And I take the showdown straight away on the touch screen. Justice Kulendi says, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? Justice Kulendi puts the question to Godfred Dame, the former Attorney General. He says, Mr. Dame, let me ask you, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? The respondent being the president, by the way. The respondent is the president. The applicant is Asifwa. The respondent is the president. Then Godfred Dame says, my lord, the failure to give the Chief Justice notice. So Justice Kulendi says, what will be the substantive constitutional breach in respect of this? And it says it is the failure to give the Chief Justice notice. That's what Godfred Dame says. Simplifies the matter. Then Justice Kulendi continues. It is a question of time as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Justice Kulendi was piling pressure on Justice Godfred Dame to demonstrate where is the constitutional breach. Show me the constitutional breach. Is it, what is the point? Article 146 says what? Does it say when, at what time? It doesn't say. That's Justice Kulendi's question. Let me read it again. It says, it is a question of time, comma, as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Godfred Dame says, the Constitution is silent on that, and that is the essence of the constitutional issues before this court. I like the banter. The judge says, show me where the thing is. The lawyer says, it is not there. That is why you are here. The purpose of the Constitution, the Supreme Court, is to give clarity to things that are either not in the law that ought to have been there, or things that lend themselves to 2 or 3 interpretations. That is the essence of the court. If there was a black and white situation, Article 146, we will not be here, my lord. We will not be here. We are here, and you, the law, your lordships, are empowered with experience and learning and teaching that can help us to be able to go through this process in a way that a constitutional court works. That was the banter between Justice Lord Kulendi and Godfred Dame. But as if Professor Mensah Bonsu was listening to both of them, she then entered into the fray with Justice Sremsai in this way. She said, the right to be heard is a constitutional right, and Article 23 requires that administrative justice should respect this right. Address the court on this, learned Attorney General. Address the court on this. So she makes a substantive statement and says, listen, the right to be heard is a constitutional right. And Article 23 requires that administrative justice should respect this right. Please address the court on this one. And then Justice Sremsai, the Deputy Attorney General, says, my lords, the right to be heard has been provided in the procedure outlined in Article 146. Hence, the issue is at what time the enjoyment of this right is to be respected. At what time the enjoyment of this right is to be respected. And then Professor Mensah Bonsu says, should the enjoyment of this right accrue after the respondent, the Chief Justice, has been tried in the court of public opinion? Sremsai says, my lords, I rest my case. So they are talking about rights. Professor Mensah Bonsu says, it is a right for everybody to have the right to be heard. Show me how this right should be enjoyed. He says Article 146 provides that the right can be enjoyed. But it doesn't say at what time the right should be enjoyed. You see, the president gets the petition, sends it to Council of State. The argument is that president gets the petition, send it first to the subject before the Council of State can have the petition and what the subject says, so that they can come to a conclusion of a prima facie. But you don't send to the Council of State only one side of the story and ask them to do a prima facie. This is the conversation going on. And they are saying that where, at which point? And Professor Mensah Bonsu is saying that, okay, if you're asking me at which point, or that the Constitution is at which point, are you suggesting to me that it's okay for you to give the document to the person after you have tried the person in court of public opinion, that is to say, after everybody has seen the petition and is gone to Council of State, is it at that time that you are going to give the person the right to be heard? After the public has seen, after the Council of State has seen, after they may have prejudged the matter, after they may have made their opinion, is it at that time that you are going to show to the subject? This was a conversation between Professor Henrietta Mensah Bonsu, who was on the minority side, writing the minority opinion of 2, and Justice Sremsai, who is the Attorney General, Deputy Attorney General, and Deputy Minister for Justice. Justice Sremsai, in answer to the rhetorical question by Mensah Bonsu, said, "My lords, I rest my case." Okay, so this is how it ended.